Welcome to Creamer Media's Polity. I'm Brad Dubbelman. I'm at the Institute for Security Studies in Pretoria to meet with Ottilia Maunganidze to discuss the recent review conference of the International Criminal Court in Kampala, Uganda. Welcome, Ottilia. What was the purpose of the recent ICC review conference?
The review conference that was convened at the end of May to the beginning of June this year was mainly to assess the progress of the court, but also to deal with outstanding issues from the 1998 Rome Conference and to make any necessary amendments where needed. For example, with the crime of aggression, the inclusion of certain crimes, as well as other issues pertaining to the Rome Statute directly.
A May 5th article by the ICS said that work at the conference should not be undermined by deliberations over the crime of aggression. And yet this topic seems to have dominated the conference. What are the problems around the crime of aggression that may undermine the ICC?
The issue with the crime of aggression possibly undermining the ICC is not that it mustn't be prosecuted. The issue is the extent of the crime, and given the fact that the court is a young court and is it currently has on its roll war crimes, crimes against humanity and genocide. So adding on the crime of aggression, in our opinion, would actually burden the court itself and not necessarily work towards the progress of the court. Not that the crime of aggression shouldn't be included. It's a necessary inclusion. But obviously there are issues relating to the politicization of the court. The nature of the crime of aggression is that it is more political than the other crimes. It relates to the commission of the crime of aggression by a member state through entering into another state by means of force. And therefore, the person or the people who will be responsible for the crime are actually the state and not necessarily individuals. Whereas with the other crimes, it's individual responsibility. So if you commit a crime, then you're tried for that crime. And that is the main problem with the crime of aggression, that it can easily be politicized.
Was a definition of the crime of aggression decided on?
Yes, it was decided on. The definition of the crime of aggression has been a work in progress since 2002, when a special working group was set to deal with the crime of aggression. And over the years, through consultations, they came up with a definition of the crime of aggression that they put to the member states that were present, as well as non-state parties and non-government organizations that were present at the review conference. And they did agree on this definition, and the definition essentially criminalizes a state going into another country's territory by the use of force.
What were the outcomes of the conference regarding the issues of complementarity, accountability and cooperation, and the important questions of peace and justice?
With regards to cooperation, the resolutions that were made in that regard were basically they link up with that of complementarity, in that member states, having signed up to the Rome Statute, need to follow through with their obligations. And so in terms of cooperation, they need obviously to offer their assistance to the court where necessary, where they're called upon. It's important to note that during the review conference, 3 countries actually signed implementation enforcement agreements with the court, allowing for them to be able to have prisoners, once they have been sentenced by the International Criminal Court, to actually house these prisoners throughout the duration of their sentence. In terms of complementarity, as is always stressed, there's domestic jurisdiction is paramount, basically, and it's important to build on domestic prosecutions. And so at the review conference, this was reiterated, basically, that there is a need not only for the International Criminal Court to be a strong institution, but also for domestic courts to be able to prosecute such crimes in order for it feeds into the work of the criminal court as well. If domestic courts can prosecute and are able to prosecute, then the work of the court is lessened because the International Criminal Court is a court of last resort.
The ISS and other NGOs have played an important role in the evolution of the ICC. What role has civil society played in the Kampala Review Conference, and what recommendations can the ISS give?
Civil society has been very integral in the work of the International Criminal Court, not least because it was civil society that lobbied quite strongly for the establishment of the court, but also because of the work that civil society does in monitoring the work of the court and in assisting the court in any way it can, it has been very, very important in the work of the court. In terms of the review conference directly, a coalition of the International Criminal Court, which has been working since the establishment of the court, has 2,500 NGOs across the world that are members of it, and of those 600 attended the review conference. The International Crime in Africa program of the ISS is part of that, and there were side events that were hosted dealing with the main issues. There was a lot of lobbying around the crime of aggression, and prior to the conference itself, as part of the CICC, we issued a statement asking that the crime of aggression not overshadow the proceedings at the review conference, so as to allow for the other issues, peace and justice, complementarity, cooperation, to be dealt with as well. And we are happy to say that these issues were dealt with. And not only that, the crime of aggression was dealt with as well, and that a definition was agreed upon. Obviously, it'll be a couple of years, at least 7 years, before any prosecution of the crime of aggression actually does happen. But it's a welcome development that we do now officially have an enforceable definition of the crime of aggression.
Thank you, Ottilia.
Thank you.